overdue.
Okay. One thing I didn't say when we got started, folks, is that we're talking about California law here, so in other states they may have other things that apply. I imagine this is a movement that's probably moving across the country, taking hold, and we're seeing more professional fiduciaries. They're going to have different standards though for a while, and then eventually we'll probably see some more uniformity that'll happen. Okay. When might a family want to have a bank or a trust company as a conservator, trustee, or executor? And what's the difference between a professional fiduciary and a bank or trust company?
Okay, that I would always encourage, and in a number of cases I am able to meet with the family members before they complete their estate planning documents. So
Yeah.
always want to go through the choices of the family member, the corporate fiduciary, and the private professional fiduciary. So people should always be aware of those three choices. But with regard to the bank, very good, very solid, got some excellent trust officers, which can give the family a good amount of longevity. With a private professional fiduciary, you're naming, in most cases, an individual.
Mm-hmm.
In fact, it's required to name an individual. You can't name a corporation unless it's a bank trust company. So by naming the trust company, you're naming an entity. You do have this continuity. So if it's a very young family, for example, you know that the bank in some form is going to be around for a long, long period of time. If there are concerns within the family about security and safety of assets, the bank trust company will be an FDIC insured entity. So you have some level of insurance. Most trust assets, however, are outside the FDIC insurance. But you do have a lot of auditing between state and federal regulators and the bank's own internal auditors. The trust officers that I talk to are constantly being audited. Mm-hmm. So, if you're concerned about, safety, reliability, and security, that can be a very good way to go. And also the longevity can be a good plug-in for that.
Mm-hmm. Okay. What about then? So you've covered some advantages of the bank trust company, and I guess that's what I focused on. But how about the other side? So why would somebody want to use somebody like yourself, an individual professional fiduciary, as opposed to the bank?
Well, literally, if you're bringing in a private professional fiduciary, you're bringing in an individual. So you're talking to the individual, you're engaging the individual will be named in the document. When you're naming a bank, typically you're not naming the individual trust officer that's in there, you're naming the bank as the entity. So by bringing in a professional fiduciary, it's somebody that quite possibly you've met before the disability, before the death has taken place. You build up a little bit of a relationship there. And also there's an element of the personal service. With a professional fiduciary, you have somebody that's available who's quite possibly a lot more local than a bank trust company would be. Mm-hmm. And they're committed to the community. They would know the local court system. They'd know the local attorneys. If the family has local real estate, there may be an element of that the professional fiduciary may be more familiar with rather than the bank trust company. And the other absolutely huge difference is that a bank will never take on a role under an advance directive for healthcare decision making. The bank will never become a conservator of the person to make healthcare decisions for somebody who's in that situation. So that is a massive difference between the corporate fiduciary and the private professional fiduciary.
Okay. What sort of oversight is there? So you talked about the bank auditors. What sort of oversight is there for your activities as a professional fiduciary?
It depends. Again, we're back to the attorney. Depends on what the facts and circumstances are. If we're dealing with a standard family living trust that's drawn up by the attorney, is operating outside of court supervision, the document is the controlling vehicle for the administration of the trust. It's really up to the beneficiaries and the family members to keep an eye on the fiduciary. That's the first line of defense. The family members really need to make sure they're getting reports from the fiduciary, they know what's going on in the trust, and so that's an initial level of control. The family or the beneficiary can always petition the court to have an accounting prepared by the fiduciary, even if it's not fully a court supervised trust. They can call for the probate code format accountings. The fiduciary will prepare those and submit them to the court. There are other elements if, for example, the trust document or the families require the fiduciary to be bonded, then the bonding company on some level will get annual reports and statements from the fiduciary. So there'll be some element involved with that. So that deals with trusts and the non-court supervised elements. For a fully court supervised trust, there is heavy control by the court. Annual accountings will be required. Any fees that the fiduciary gets paid will have to run through the court to get approval. A nomination or being named as an executor under a will be a court proceeding also. So again, the accounts are submitted to the court. There's approval for fees put in that direction. The last category that I wanted to cover in terms of supervision would be conservatorships. Here clearly you're dealing with somebody who doesn't have capacity at that time and is a very, very vulnerable person, so there is full oversight by the court. So the court investigator will be involved, the probate examiners will be involved. Before there's even an appointment, there'll be a review of assets, review of the fiduciary, the elder, so very heavy control in that case. So in terms of the controls and the oversight, there's a huge range. So far as the fiduciary themselves are concerned, the Department of Consumer Affairs does have annual renewals for their licenses. So if there is a complaint filed, there'll be an investigation by the Department of Consumer Affairs. Reports would have to be filed for that. So there is the oversight through the licensing, in addition to the courts, the family members, and that element as well.
Okay. Can you tell us anything about the Professional Fiduciaries Association of California?
Okay, this is commonly known as PFAC, and this is an organization that was formed by 3 regional outfits within the state of California. A component of people from San Diego, Los Angeles, and then Northern California got together in 1995. So since 1995, we've had PFAC as a statewide organization. I regard membership in PFAC as pretty much essential. Not actually required, but my belief is it's absolutely essential. Providing a lot of continuing education and networking with other fiduciaries. With the type of work that we do as fiduciaries, there are always situations that you come across that are new to that individual fiduciary. Even after 30 years of doing this, I get things on a regular basis that I can pull other expertise into. So PFAC is a great organization, very influential in formulating the legislation for licensing and some subsequent amendments to the licensing legislation. Okay.
Okay, Richard. You gave me a couple of questions here to throw out. I think I'm going to start, because we've got about 5 minutes left. So I'm going to start with the last one first, and that is, what is the worst situation that you've ever seen when taking over from an individual or a family member, trustee, or conservator?
Yeah, well, the notes that I have on that is, and of course I can't use family names, although we could probably piece it together, was a gentleman who's a single gentleman, never had any children, so we talked about that before. The attorney is somebody that I've known for a number of years who named me in the document. So when the gentleman became disabled, I was called. Unfortunately, he passed away before I could become activated as the trustee. So first thing, as I said to start out with, pulled out a copy of the document and saw that within the document, this gentleman was very attached to his church. So the estate went to the church to the extreme chagrin of his 3 nieces and nephews.
Oh dear.
The 3 nieces and nephews each got $1,000 out of a $3 million estate. And that was very difficult telling them that because they didn't even initially, although I persuaded the charities, the religious organizations, to allow the family members to take personal items out of the house, photographs and that sort of thing. Yeah. So that's very, very difficult, because immediately the person, if it's somebody such as myself, or it could have been another individual, maybe the neighbor might have stepped in unbeknowing, suddenly you're involved with that, there's this extreme animosity. These folks thought they were going to get a pretty substantial inheritance, ended up with $1,000 in the bank. But there we go. And that's actually the second situation that I've had where the family was disinherited, and the first situation the family got absolutely nothing, and again it was a real struggle going through convincing the charities to give at least something. I think the father's burial flag, he was in the military, so we got the burial flag and the family Bible given out to the family members. In that case, I did make the attorney who'd written the document sit down with the family and explain that they were disinherited. So I thought the attorney deserved that. So,
I think so, yeah. Why should you be stuck with that? Oh my gosh. Well, what's the best situation? And again, bear in mind we've got less than 2 minutes.
Yeah, probably the best situation, somebody who'd seen their attorney ahead of time, got a qualified trustee involved, but this particular gentleman had read the letter from the attorney. Most people don't read the letter from the attorney. The letter from the attorney said, retitle all of your assets. And this person had about 27 mutual funds. He retitled every single last one of them into his name as trustee. Perfect.
That just helps an awful lot. So
Yes.
everything is in the trust, and you don't have to go through a lot of special petitions and all the other things to sort of clean up.
Yeah, he did a great job.
So it helps, if people pay attention to those details, particularly for funding for trusts. So it does make it nice. And by the way, I helped my father-in-law to get his stuff taken care of, and we made sure that all of his titles were all in good order, and so made it pretty easy to administer his. And he also had probably 30 mutual funds. So if you've got a lot of those accounts, it can be a real headache if it's not done. Okay, Richard, I think maybe we have time for you to just throw out a final thought for less than a minute.
Yeah, looking down at my notes here, I've got a huge word here, and it's called planning. Mm-hmm. For people to think about their estate plans, the types of assets, if they can simplify the assets, just for their own personal peace of mind. That I think is absolutely essential. Take the risk out of their assets if they possibly can, and pay attention to what the attorneys are saying, pay attention to what the CPAs are saying, because the simpler the plan is, my belief is the more effective it will be.
Mm-hmm. Okay, great. Richard, thanks so much for joining me, being
You're
my
welcome.
guest today. It's a pleasure having you. Folks, I hope we've given you some food for thought. A professional fiduciary is a viable alternative. You've heard some things that they can actually do that even a bank trust officer can't or won't do. And anyway, again, it's a matter, I think, largely of a personal relationship and personal service that they can do. And I know a number of these people in Santa Clara County, and Richard is one of them, that do a great job, and really appreciate their being there for us. We'll see you next time on Financial Insider Weekly.